was sustained or is in imminent danger of sustaining injury from the act complained of. Thus, what does this require? This simply says that if you go to court and ask the court to declare a legislative act or an act of the executive department as unconstitutional, you must show that you have sustained an injury or you are in imminent danger of sustaining injury from the act that you are challenging. As a rule, you cannot challenge a governmental act if you do not suffer or if you are not in danger of suffering injury from that governmental act you challenge. Again, in San Lakas versus Secretary Reyes, the political parties, San Lakas, Partido ng Manggagawa, the NGOs who were petitioners in the companion cases filed were declared not proper parties. Why not? The Supreme Court said these are juridical persons. Juridical persons are not subject to arrest. The fears that the petitioners aired when they filed the petitions, that the state of rebellion declaration could lead to warrantless arrests, etc. Perhaps the best example would be Hoya versus PCGG. In Hoya versus PCGG, Hoya and several other national artists went to court to try to stop the public auction conducted by PCGG, at which were to be sold paintings and other works of art. These are masterpieces. The Supreme Court dismissed the petition, saying that Hoya and the other petitioners never said that they were owners of these works of art. Accordingly, the Supreme Court said they were not proper parties. There is, however, according to Justice Vicente Mendoza again, one instance when a person or a party who will not sustain an injury may validly go to court and challenge the constitutionality of a governmental act. This is what Justice Mendoza calls a facial challenge. Unfortunately, these have been raised by Justice Mendoza only in a number of his concurring opinions. Hindi mo mababasa sa ponensya mismo. So, nonetheless, I think it is worth knowing, after all, even if Justice Mendoza will not be the examiner, it could be somebody who likes the ideas of Justice Mendoza. Facial challenge. Ano sinasabing Justice Mendoza? A party who will not sustain an injury may validly go to court to challenge the constitutionality of an act of government if it can show that that will inflict injury upon others, where the act on its face is invalid or unconstitutional. Justice Mendoza also said that this shall apply only to cases involving repression or suppression of freedom of expression, where, according to him, the governmental act is invalid because of the overbreadth doctrine. The governmental act then, to be challenged under this mode, must be so broad, so comprehensive, that it will affect not only unprotected but also protected freedoms. However, in the same breath, he said, kaya overbreadth, under the overbreadth doctrine. And in the same breath, he said, this is the most difficult of all challenges to mount. Because a facial challenge can be mounted only when it is shown that under no circumstances is the governmental act valid. Then class, please remember three related principles to this. First, that principle laid down by the Supreme Court in Kilos Bayan versus Lingona. What did the Supreme Court say there? Supreme Court declared that the proper party requirement is only a procedural technicality which the court may brush aside when the issues raised are of transcendental or paramount importance. What happened in Kilos Bayan versus Lingona, briefly? The Philippine government decided to operate lotto in the country. The legal advisors of Malacanang saw that in the charter of the Philippine Charity Sweepstakes Office, there was authority to engage even in lotto, though not in so many words. And so, okay, we will have lotto. It will be operated by PCSO. PCSO said, we do not know how to operate lotto. So what did they do? They said, let us ask a foreign company to operate lotto for us. Let us bid out the actual operations of lotto in the country. And that is what they did, bid out. Winning bidder. Okay. Contract entered into. Kilos Bayan, an esoteric organization composed of former government officials, businessmen, civic leaders, and outright pakialameros, pakialameras, and mga ganyan, went to court to challenge this. One of the first issues raised, of course, was that Kilos Bayan is not a proper party. The Supreme Court recognized that Kilos Bayan is not a proper party. But, sabi ng Supreme Court, the issues raised by Kilos Bayan are of such paramount importance to the country that we now brush aside the requirement because of the importance of the issues raised. And so, class, yun ang isang. Although, of course, if you look at Kilos Bayan versus Lingona, you should look at the subsequent ruling also in Kilos Bayan versus Morato. Because in Kilos Bayan versus Lingona, the Supreme Court invalidated the governmental act of bidding and allowing and entering into a contract with a foreign company to operate lotto. So hindi natuloy yun. Hindi natuloy. Ano ang ginawa ng PCSO? Tayo na ang mag-operate. Hindi pwede kung foreign company ang mag-operate ito. Tayo ang mag-operate. Nagpadala na sila ng mga tao to study how lotto should be operated. And then when these people came back, ayos na tayo, meron na tayong marunong. They saw a problem. Anong problema? We do not have the equipment, the facilities for lotto. So the next best thing was, let us lease from the winning bidder the equipment that we will use for Lotto. Tayo mag-operate, pero equipment nila ating i-lease. Okay. They entered into a lease contract for the equipment. Again, Kilos Bayan went to court. Ay, ito na naman ang Kilos Bayan. The same issue. Is it a proper party? The Supreme Court this time said, no. Kilos Bayan is not a proper party. It has not shown that it has any present substantial interest in the subject matter of the action. Therefore, its petition should fail. So, Kilos Bayan versus Gingona, ang principle na kailangan matandaan. The proper party requirement is only a procedural technicality that can be brushed aside if the issues raised are of paramount or transcendental importance. Okay. The second principle I want you to remember has to do with taxpayer suits. A taxpayer is of course a proper party to contest the validity of the tax as a tax law that imposes a tax on him. By requiring him to pay a tax, he will sustain an injury. So, proper party talaga siya. Now, he is also a proper party to contest the validity of any governmental expenditure which is challenged as irregular, expensive, extravagant, scandalous, improvident, etc. So the Supreme Court said that in order that there may be a valid taxpayer suit relative to expenditures of public funds, it must be shown that there is an expenditure of funds undertaken by a government agency, officer, or instrumentality, and that in such expenditure there is a violation committed, such that the expenditure is unlawful or irregular. And second, the taxpayer must show that he is directly affected by such an expenditure. Thus, as taxpayer, when there is an illegal expenditure of public money, he will sustain an injury because part of that money is spent may come from the taxes that he pays government. That is why the taxpayer is a proper party. Third principle I want you to remember is that laid down by the Supreme Court in an old case, the case of People versus Vera. In People versus Vera, the Supreme Court said, the government of the Philippines is a proper party to contest the validity of its own laws because more than anyone, the government has a basic interest in the validity of its own laws. In this case of People versus Vera, what the government challenged as unconstitutional was the probation law passed by Congress. Una pa ito, hindi ito yung ating probation law ngayon. Una pa ito. Ano sabi ng Supreme Court? The government certainly is a proper party to say that that probation law is unconstitutional. More than the injury caused by government having to spend money on this probation law that is contrary to the Constitution, sabi ng Supreme Court, is the mortal wound that will be inflicted on the body politic by having an unconstitutional law. And so the government is a proper party to contest the validity of its own laws. Siguro with that, more or less, i-apply nyo na lang itong ating principles. The third requisite is, of course, that the question of constitutionality must be raised at the earliest possible opportunity. When is the earliest possible opportunity? The pleadings. So the issue must be raised in the pleadings because as a rule, if not raised in the pleadings, it cannot be raised during the trial, and it certainly cannot be raised on appeal. In the case of Umali versus Gingona, the petitioner went to court to challenge the constitutionality of the presidential Act creating the PAGC, the PCAG, the Presidential Committee on Anti-Graft and Corruption, PAGC. Yeah. But the challenge was made only on motion for reconsideration. The Supreme Court said it is too late in the day for the petitioner to raise the issue of constitutionality only on motion for reconsideration. However, there are three acknowledged exceptions to the rule. First, in criminal cases, the question of constitutionality of a law may be raised at any stage of the proceedings at the discretion of the court. Second, in civil cases, the question of constitutionality can be raised at any stage of the proceedings when necessary for a final determination of the action itself. And third, in criminal or civil cases, the question of constitutionality may be raised at any stage of the proceedings whenever it refers to the jurisdiction of the court, unless in the meantime he who challenges the constitutionality of the act is under stoppage and is prevented by stoppage from raising the issue. Fourth, the fourth requisite is that the resolution of the constitutional question must be determinative of the case itself, which means that the case pending in court, the actual case or controversy, cannot be decided or cannot be resolved unless the court decides the question of constitutionality. Principles of comity, or if you will, the principle of separation of powers, make courts loath to interfere in actions of co-equal departments of government. And so only when the case cannot be decided without having to rule on the question of constitutionality may the court decide the question of constitutionality. Perhaps the case of Tarosa versus Simpson is illustrative. What happened in Tarosa versus Simpson? In Tarosa versus Simpson, a private citizen went to court to challenge the appointment, the validity of the appointment of Gabriel Simpson as governor of the Bangko Sentral ng Pilipinas. Under the new law, mandated under the Constitution, the new law creating the Bangko Sentral, it is provided that the governor shall be appointed by the President of the Philippines upon confirmation by the Commission on Appointments. Fidel V. Ramos appointed Gabriel Simpson as governor of the Bangko Sentral. That appointment was never submitted to the Commission on Appointments. And so a challenge was made. In his answer, Gabriel Simpson said that provision in the law requiring confirmation by the Commission on Appointments is unconstitutional, as already held in a number of cases. Sarmiento versus Mison. This was also made reference to in Mary Concepcion Bautista versus Salonga. And again, of course, in the case of Calderon versus Carali. Despite this seasonable raising of the question of constitutionality, the Supreme Court did not rule on the question of constitutionality. Instead, the Supreme Court dismissed the Tarosa petition on other grounds, on principles in the law of public offices. We will discuss this later, but at this point it is probably necessary to make reference to the principle already. Where the power of appointment is exercised by the repository of the power, either under the Constitution or under the law, and the appointee possesses the minimum qualification requirements for the public office to which he is appointed. The act of appointment partakes of the character of a political question. It can be questioned only upon a petition for quorum filed by the Solicitor General or by any person who claims that he has a better right or a better title to the public office that he is contesting. Kaya, yung mga protest ng appointments for all of you who are, for those of you who are in government, those protests are really in the nature of a quorum petition if filed in court. The protestant claims that he has a better right to be appointed to the office. That is supposed to be the basis for the protest. Now, in Tarosa versus Simpson, the Supreme Court said, the petitioner does not claim that he has a better right to the position of governor of Bangko Sentral. He does not claim that he has title to the position. Accordingly, this case not being a petition for quorum or the equivalent at least of a petition for quorum may be dismissed as it was dismissed. No necessity to decide the question of constitutionality because some other ground can be used by the court to decide the case. That is what happened in Tarosa versus Simpson. All right. So, if a problem is asked in the bar examinations regarding the necessity, the validity of the exercise of the power of judicial review, test the facts of the problem in light of compliance with the 4 requisites. Kaya, isipin nyo, yung 4 requisites lang ang kailangan maintindihan eh. Yun lang. You can solve any problem judicial review using these. Kailangan lang may presence of mind ka. Huwag kang magpadala agad sa unang nakita mo ka kung ano naisip mo. Relax lang. Test the facts of the problem in light of compliance with these requisites and you won't go wrong. Of course, remember our exceptions, yun din. Iilan lang naman yan at madali pati maintindihan, madaling marikon. So, yun. Alright. So what happens when a law or an executive act is declared unconstitutional by the courts in the exercise of the power of judicial review? We have 2 schools of thought. We have the orthodox view which says that a law or any governmental act for that matter that is declared unconstitutional confers no rights, imposes no obligations, it is stricken off the statute books, it is as if it had never been passed before. Then we have the modern view, where the court simply refused to recognize the existence of the law at the point of its declaration of unconstitutionality. What is the difference between the two? The difference is that in the orthodox view, you will not recognize any legal effect of the governmental act at all because it is not supposed to produce any rights. It is as if it had never been passed at all. And this is supposed to be consonant with Article 7 of the Civil Code. Yet, of late, the Supreme Court has been using the modern view, recognizing certain legal effects of the law prior to its declaration of unconstitutionality. Thus, for example, persons who may be appointed under a law that will later be declared unconstitutional will not be made to reimburse whatever it was that they received as salaries. They will be considered as de facto public officers and be entitled to compensation, salaries, etc. Eh kung orthodox view yun, sa uli lahat. Isipin nyo, kung doon sa opisina nga, merong mga party-party, kumain kayo, gano'y pasusukan natin. Ang constitutional ito. Isipin ka mangyayari niya. Kaya hindi pwedeng puro orthodox view na lang. Alright. The only other point I want you to remember in connection with judicial review is the matter of partial unconstitutionality. As often happens, the declaration of unconstitutionality is only of a certain provision in the law, not the entire law itself, kadalasan. Now, what happens when a provision of law is declared unconstitutional? Will the rest of the law not declared unconstitutional remain valid law? The answer is yes, provided there is compliance with two requisites. Number one, the legislative intent must be clear that Congress would have passed the law without the unconstitutional portion. This legislative intent is expressed very often in what is known as the separability clause. The separability clause in the law is that provision that says if any part of this law, of this act is declared unconstitutional, the rest shall remain valid. And of course, the second requisite is that the remaining portions of the law, after you take out the unconstitutional portion, can stand independently as law. If you have a law that is composed only of 3 sections, Section 1, title, this act shall be known as the whatever act of 2005. Section 2, yung meet. Section 3, this act shall take effect upon approval. Section 2 declared unconstitutional. Wala ka na. Ayos ka na. No partial unconstitutional. Alright. That should take care of judicial review. We move on next to the concept of the state. In this discussion, we look at principles of a state from the constitutional law point of view. Although we will see that many of these principles impinge on principles in public international law, which some of you have mastered also, you know. Okay. State. A state is defined as a community of persons more or less numerous, permanently occupying a definite portion of territory, independent of external control and possessing a government to which a great body of inhabitants render habitual obedience. From this definition, we are immediately introduced to the fact that there are 4 elements of a state, namely people, territory, government, and sovereignty. In public international law class, this is the majority school of thought. 4 elements: people, territory, government, and sovereignty. There is a minority school of thought that says there are 6 elements of a state in public international law: people, territory, government, sovereignty, recognition by other states, and number 6 is possession of a relatively high degree of civilization. But minority, small minority na ito ngayon. Alright. Let us look at the elements briefly. Insofar as the distinction between a state and nation are concerned, medyo, political science na yan. Nation being an ethnic or cultural concept, while the state being a legal concept. Kaya hindi nagtutugma yun. You do not distinguish between two na hindi nagko-conflict, nagkakaibang levels. Alright. Elements. People. People as an element of the state refers to the human beings who inhabit the territory of the state. From the definition, they are sufficiently numerous. This number is necessary for purposes of sustenance and defense. However, look at the Vatican State ngayon. Iilan lang ang people dyan. Mabuti na lang at meron silang ibang people, mga employees, mga Swiss guards, mga ano. Kasi kung ang people dyan, ang mga pang-pope lang at mga cardinal, kawawa naman, hindi naman procreate, hindi mauubos sila. Mauubos ang people dyan. Kaya, the need also for the people to be composed of at least 2 sexes in order to procreate and to make possible succession. 2 sexes, dahil ngayon marami ng sexes, may mga nag-aasawa ng mga susnak ng puga naman. Hindi ko maintindihan ito. Pero, ay, nako. Anyway, yun. Purely from an academic point of view, when the word people is used in the Constitution, it could refer to different things. People as used in the preamble refers to Filipino citizens because only Filipino citizens can ordain and promulgate the Philippine Constitution. People as used in Section 2 of Article 3, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, refer to natural, juridical, they refer to aliens, citizens, young, old, male, female. Now, in Article 7, it is provided that the President of the Philippines shall be elected by a direct vote of the people. People there would refer to registered voters, or at least qualified electors. So in that sense, people may differ in meaning depending on the use in which the word is placed in the Constitution. Okay. Territory. The territory as an element of the state refers to the fixed portion on the face of the earth where the people live. Accordingly, as a rule, the components of the national territory of a state are your terrestrial domain, the fluvial domain, the maritime domain, and the aerial domain. The terrestrial domain, of course, refers to the land mass where the people reside. The fluvial domain refers to the internal waters, the lakes, the rivers, the bays, the gulfs, and later we will see that they can include even the waters around between and connecting the islands of an archipelago. The maritime domain refers to the territorial sea. What you used to call the maritime zone is now, of course, denominated the territorial sea. And in public international law, the accepted area which is supposed to be part of the territorial sea shall be 12 miles reckoned from the low water mark in a single island state. Kung single island state, the territorial sea shall extend up to 12 miles from the low water mark. The low water mark is the lowest point on the shore that the water reaches at low tide. Okay. The aerial domain, of course, is the airspace above the terrestrial, the fluvial, and the maritime domain. Of course, class, there are states which may not have all four. In Europe, for example, there are states that are landlocked. A, B, C, D, E, and F. D would have no maritime domain because its borders are landlocked. So it's possible that a state may not have maritime domain. All right. It is in this connection then that we look at Article 1 of the Philippine Constitution on the national territory of the Philippines. Section 1, Article 1 says, the national territory comprises the Philippine archipelago, with the islands and waters embraced therein, and all other territories over which the Philippines has sovereignty or jurisdiction, consisting of its terrestrial, fluvial, and aerial domain, including the territorial sea, the seabed, the subsoil, the insular shelves, and other submarine areas. That is the first sentence, and that is what we will talk about first. The Philippine archipelago, with all the islands and waters embraced therein, and all other territories over which the Philippines has sovereignty or jurisdiction. Yung una muna, the Philippine archipelago. Ang problema ng Section 1, hindi mo ma-picture sa utak mo saan ba ang borders ng Philippines. The Philippine archipelago, with all the islands and waters embraced therein. And so, class, the real test would be by reference to organic acts affecting precisely this territory of the Philippines, starting with the Treaty of Paris of December 10, 1898, by virtue of which Spain ceded the islands to the United States for the sum of 20 million pesos. So even at the outset, class, America bought the Philippines. Now America continues to buy Filipinos. So, okay. In public international law, you will find an old case in relative to the Las Palmas Islands, which were supposed to have been part of the cession by Spain to the United States, but which later was claimed by Holland, by the Netherlands. And the Netherlands won the international law case over the U.S. by virtue of occupation. Okay, but that's public international law. What I am trying to say is that the Treaty of Paris of December 10, 1898 is your reference point. Alin dito sa islands ang covered dito? Yeah. Then, of course, another organic act affecting the Philippines was the treaty entered into by Spain and the U.S. in Washington on November 7, 1900. Because under this treaty, there was recognition that included in this cession were Cagayan, Sulu, and Cebu. And then we still have another treaty. The treaty entered into by the U.S. and Great Britain on January 2, 1930, which covered the Turtle Islands and the Mansi Islands. Alright. Yeah. To determine then the extent of this Philippine archipelago that we refer to in Section 1, with all the islands and waters embraced therein, ito ang ating basis. And then the next phrase is, and all other territories over which the Philippines has sovereignty or jurisdiction. Justice Cruz, I think it was Justice Cruz, who said that if you look at this treaties, Batanes does not appear to be included in the Philippine archipelago. Baka naman magalit si Secretary Abad. Batanes. But, sabi niya, by virtue of the Philippine Constitution of 1935, Batanes now is part of the national territory of the Philippines. In addition to that, we should look at the provision of the Constitution of 1973, where in the definition of the national territory of the Philippines, we find the phrase belonging to the Philippines by historic right or legal title. Historic right or legal title. Of course, in 1973, this had to be included because there had to be some constitutional basis for our continuing claim that Sabah was part of the Philippines. And then finally, in 1978, President Marcos issued PB 1596. This should be related also, class, to the controversy over the Kalayaan Islands, the Freedom Islands. When we learned that Justice Kokya was bar examiner several years ago, sa lahat ng aking review classes, talagang sinabi ko, lalabas yung question na yan. Justify the Philippine claim to the Freedom Islands or to the Kalayaan Islands. Or it could be in a problem or hindi naman lumabas. It was much later when Justice Kokya was no longer the examiner that the question was asked. Alright. If that question is ever asked again, or if the question says, who among the claimants, People's Republic of China, Vietnam, the Philippines, please do not answer Vietnam. It should be, of course, the Philippines. The Kalayaan Islands were supposed to be discovered by a Filipino explorer named Tomas Loma. From your mastery of public international law, you know that discovery alone does not vest title over territory in the state. Discovery must be accompanied by occupation. So, in public international law, one of the modes of acquiring territory is by discovery and occupation. Tomas Loma, of course, claimed that he did not only discover, but that he also occupied the islands. Then, many years later, Tomas Loma executed a deed of assignment, assigning all of his rights over the islands to the Republic of the Philippines. President Marcos, during his incumbency as president, then asked, on the basis of this, then asked that a new map be prepared of the Philippine archipelago, which will include the Freedom Islands or the Kalayaan Islands. A copy of this map and the technical description is contained in PD 1596. A copy of the PD, a copy of the map, and the technical description of the Philippine national territory of the Philippines has been filed with the Office of the Secretary General, with the Secretariat of the United Nations. And of course, Philippine authorities continue to claim that over the years, the Philippine government has exercised sovereignty and jurisdiction over the islands. In fact, a number of the inhabitants, I don't know if they are really permanent inhabitants there, have continuously registered and voted in Palawan to show that they, the inhabitants, recognize the sovereignty of the Philippines over the islands. All of these things taken collectively support the Philippine claim that the Kalayaan Islands is part of the Philippine archipelago. Okay. So yun na, Philippine archipelago and all other territories over which the Philippines has sovereignty and jurisdiction, consisting of terrestrial, fluvial, and aerial domain, including the territorial sea. The territorial sea, we said earlier, is 12 miles, no? Territorial sea, the seabed. The seabed is, of course, the land under the sea. The subsoil. The subsoil is what is under the ground. You dig down deep, up to the center of the earth. That's what belongs to the... In America, they have what they call the China syndrome. You know what the China syndrome in America is? They say that in America, if you dig deep enough, all the way down, then you will come out in China. That is the China syndrome. So the seabed, the subsoil, the insular shells. In public international law, you do not call them insular shells. They call them continental shells. And there is a precise definition of what a continental shelf is in public international law. That should be your definition of your insular shelf. And of course, other submarine areas. Noon, within the context of constitutional law, ang insular shelf has always been understood to refer to, class, from the shore. Ang land sa shore, gradual na ganyan . Here are your waters already. Itong land, gradual, pababa. And then at a certain point, there is an abrupt dip several miles away from it. This used to be known as the insular shelf. Yang biglang palalim ng nandun na yung si Nemo, si... Okay. But if I were the bar examiner, my question will not be on the first sentence of section 1. It will be on the second sentence. Because the second sentence is the articulation of what we call the archipelago or the archipelagic doctrine of national territory. The second sentence says, The waters around, between, and connecting the islands of the archipelago, regardless of their breadth or dimension, form part of the internal waters of the Philippines. Memoryahin nyo at least yung second sentence. Madali pati. Waters around, between, and connecting. A, B, C. The islands of the archipelago, regardless of their breadth or dimension, form part of the internal waters of the Philippines. Tingnan niyo ito, ha? Okay. So, after the UN Convention on the Law of the Sea, there has been virtual international recognition of the archipelagic doctrine of national territory. The Philippines, Indonesia, Malaysia, other archipelagic states all over the world actually supported the adoption of the archipelagic doctrine. How does the archipelagic doctrine work? It is supposed to be implemented by the straight baseline method. Sa susunod na taon, hindi naman sa iniimbita ko kayo uli sa ganito. pero kasi ang akin, kuminsan pag malayo na hindi na masyado nababasa eh. Pag matagal na rin, hindi na rin nababasa sulat ko eh. Next year, maggawa na tayo ng PowerPoint presentation para yung mga ganyan hindi na kailangan isulat pa. Pinipindot na lang. Meron na ngayong bagong may screen. Ikaw meron lang dito parang lighted na pwede sinusulat mo lang nakaagad dun sa screen. So, high-tech na. Kailangan gumawa na tayo ng ganyan na dito isusulat doon sa examination booklet na okay. Under the straight baseline method, we are supposed to connect the outermost points of the outermost islands of the archipelago through imaginary straight lines. Outermost points of the outermost islands of the archipelago through straight baselines, and the waters inside the baselines shall then be considered as internal waters. Internal waters. Recall, class, what we said earlier. If you have a single island state, your internal waters are the rivers, the lakes, bays, and gulfs in public international law. A bay may be part of the internal waters or could already be part of the maritime domain or the territorial sea depending upon the size of the mouth. And that is, you take that up in public international law. Okay. Yun ang internal waters because you are supposed to reckon your territorial sea from the low water mark, 12 miles. Dito ngayon, in an archipelago, not only the rivers, the lakes, the bays, or the gulfs shall be considered as internal waters. Even the waters around, between, and connecting the islands of the archipelago are to be considered internal waters. And again, class, in public international law, the exercise of jurisdiction the coastal state over its internal waters is stricter than over the territorial sea. Over the territorial sea, foreign vessels can pass claiming right of innocent passage, right of involuntary arrival, like arrival under stress. But over internal waters, the state can prevent foreign vessels from entering a river. Here, for example, we can prevent any foreign vessel from entering Pasig River. Although, of course, I don't see any reason why somebody would like to go to Pasig River. Or polluted, not polluted, why would a foreign vessel want to go there? But, because the exercise of jurisdiction, the exercise of jurisdiction over the fluvial domain is almost as comprehensive, as plenary as the exercise over the terrestrial domain. Dito sinasabi natin, kaya meron tayong even in the exercise of criminal jurisdiction, which you have mastered, meron tayong French rule, English rule, on offenses committed on foreign vessels within the territorial sea of the coastal state. Ito ngayon, technically, since these waters around, between, and connecting the islands are internal waters, technically, the exercise of jurisdiction by the archipelagic state is such that it is as if these are all rivers, lakes, etc. as the internal waters. And so, how do you now measure the maritime domain? How do you now reckon the territorial sea? You reckon the territorial sea no longer from the low water mark. You reckon the territorial sea from the baselines. You see how large the territory of the archipelagic state now is. Okay. Back to the straight baseline method. These straight imaginary baselines connecting the outermost points of the outermost islands of the archipelago, however, should not result, according to public international law, should not result in a ratio greater than 9 parts water to 1 part land. The ratio allowed is 9 to 1, not to exceed 9 to 1. And further, that the general configuration of the archipelago after drawing the baselines should not appreciably depart from the configuration of the islands. Yun ang dalawang limitations on the application of the straight baseline method. Okay. Now, what are we saying about rights of foreign vessels? Right of foreign vessels. Vessels can enter your maritime zone or your territorial sea in the exercise of the right of innocent passage. Pero paano? Theoretically, they have no right to enter the archipelagic waters, which are now internal waters. Plus, okay, while they are called internal waters, and you also call the rivers, lakes, internal waters. Now, technically, your fluvial domain may refer to your rivers, etc., while the waters around, between, and connecting the islands are known as archipelagic waters. The Constitution mentions this every now and then. There is a mention by the Constitution of archipelagic waters in Article 12 on the right to exploit, utilize all marine resources in internal waters, archipelagic waters, territorial sea, and the exclusive economic zone shall be open only to Filipino citizens. Okay. Now, three more things, and then we are through. Why is the archipelagic doctrine now recognized? What is the rationale for the archipelagic doctrine? The reason for the archipelagic doctrine is that an archipelago, because it consists of several islands separated by bodies of water, must be treated and considered as one integral unit. Kaya, with the baselines, ang tingin mo na ngayon, isang unit na lang yan. That is one integral whole. It is as if the entire thing is all composed of land. Be that as it may, class, where, for example, between two islands in an archipelago, there is a vast expanse of water. Foreign vessels may be allowed to pass through this vast expanse of water. Under the UN Convention on the Law of the Sea, this is recognized. These channels through which foreign vessels may pass between islands in an archipelago where the islands are separated by a vast body of water, these channels are known as archipelagic sea lanes. Alright. Then, class, under the UN Convention on the Law of the Sea, there is also recognition of 12 miles. If it were a single island state, 12 miles from the low water mark would be the territorial sea. 12 miles from the boundary of the territorial sea would be the contiguous zone. And 200 miles from the low water mark, 200 miles would be the exclusive economic zone. Notice again that because of the UN Convention on the Law of the Sea, even the Constitution, the 1987 Constitution, speaks of the exclusive economic zone. Because the contiguous zone being outside the territorial sea, and the great portion of the exclusive economic zone being outside the territorial sea, no longer form part of the national territory of the Philippines or the national territory of the state. They do not form part except the exclusive economic zone, yung 12 miles, the territorial sea. Yung 188 miles, hindi na, not part of the national territory of the state. But the state enjoys preferential rights over all the marine resources found in the contiguous zone and in the exclusive economic zone, and may therefore enforce its laws over that territory even if the territory no longer belongs technically to the state. And so from your mastery of criminal law, one of the principles governing criminal law is the principle of territoriality, that the state may exercise criminal jurisdiction only over offenses committed within its territory. Here, offenses committed outside the territory, in the contiguous zone or in the exclusive economic zone, may be validly redressed by the state in an exercise of extraterritorial jurisdiction. Now, isa na lang. Sa exclusive economic zone, dahil mahaba masyado yung 200 miles eh. Kung halimbawa, State A, State B, 200 miles hanggang dito, yung B naman 200 miles hanggang dyan, there will be an overlapping of this exclusive economic zone. As a rule then, the two states will enter into a treaty and agree on common use of the overlapping area of their respective exclusive economic zones. Okay. I think that takes care of Article 1 and 16 articles. and yet we are not yet finished with general principles. Alright. The next subject area then in state that requires discussion is government. Government as an element of the state. Government is generally defined as the instrumentality through which the will of the state is formulated, expressed, and realized. But this definition, I don't even comment to your, for you to memorize. I would rather that you memorize the first paragraph of Section 2 of the Administrative Code of 1987. It defines the government of the Philippines. Not necessarily for political law only. This can be used in most other subjects. For example, in remedial law, you speak of what? Of fees, filing fees, appeal fees, etc. But the government, of course, shall be exempt from the payment of these fees. Which government do you refer to when you speak under the rules of government being exempt from the payment of these fees? Class Government of the Philippines as defined in Section 2, Paragraph 1 of the Administrative Code. It is the corporate governmental entity through which the functions of government are exercised over in the Philippines, including, save as the country appears in the context, the various arms through which political authority is made effective in the Philippines, whether pertaining to autonomous regions, provincial, city, municipal, barangay, or other forms of local government. Madali mamemoryahin yun, lalo na sa kamukha ninyo. Ito ang ano mo. After only 2 weeks of reading, you will find that you have honed your faculty of memory to a very, very sharp level. Sandali ka lang, miskin mga suyapan mo lang, memorize. Yeah, so, pag medyo ano ka lang, hindi mo mga ganado ka lang. At pag wala ka namang ganang, miskin na malalong klase, basa, hindi ma-memorize. Okay. Now, as far as I'm concerned, For purposes of the bar exams, there are only 3 subject areas in government that you should remember. First, the doctrine of parens patriae, even as it is an old doctrine. Okay. The doctrine of parens patriae says that government is the parent of the people and may therefore interfere in order to protect the interests of the people, particularly those who are marginalized, disabled, or impoverished, etc. Government of the Philippines versus Monte de Piedad. Old case. Earthquake in the Philippines. Many people rendered homeless, victims of the earthquake. Many people from Europe contributed money, sent the money here to the Philippines to assist the victims of the earthquake. Most of this money were deposited in Monte de Piedad Bank. Unfortunately, the donors did not have specific beneficiaries or recipients. Kaya, kwarta lang for the victims. Pero, nobody could withdraw the money from Monte de Piedad. And so, since nobody could withdraw, the government said, we will withdraw for you. But Monte de Piedad refused. And so, government went to court, asking the court to order the bank to release the money to the government so that the government can distribute the money to the victims, the true beneficiaries of these donations. Remember, class, this happened a long time ago, when government could still be depended upon to distribute the money. Maganda ito. So what did the Supreme Court say? The Supreme Court said, yes, of course, government as parents patriae can do that. In Cabañas versus Pilapil, the Supreme Court invoked the doctrine of parens patriae in ruling that a natural mother should hold the proceeds of an insurance policy in trust for her natural child. In this case, what happened was illegitimate child. Okay, illegitimate child. The father, the natural father, took out an insurance policy on himself and named his natural child as the beneficiary. When the father died, the child was still a minor and so could not receive the proceeds of the insurance policy. A contest arose on who shall hold in trust for the child the proceeds of the insurance policy. The contestants were the mother of the child and the uncle of the child, the brother of the natural father who died. The court ruled in favor of the mother and in the process said that the principles of parens patriae apply. Okay. The next area that I would like you to look at and remember is the functions of government. Okay. Theoretically, the functions of government have been classified into constituent and ministerial functions. Constituent functions being mandatory for government because they constitute the very bonds of society, such as maintenance of peace and order, marriage, property rights, etc. And the ministerial are supposed to be functions intended to help promote the prosperity, the progress of the inhabitants, and are merely optional for government to perform. This used to be separate from one another. However, class, as early as Philippine Virginia Tobacco Administration versus Court of Industrial Relations, the Supreme Court said that the distinction between the two functions has become blurred. Why? Because what were traditionally considered ministerial functions of government have now become mandatory for government to perform by virtue of the social justice provisions in the Constitution. 70 years ago, housing was not a mandatory function of government. Today, it is. There is ample constitutional principle. There is an ample constitutional mandate for government to provide adequate housing for our people. And so, ganyan. And it is in this connection, class, I am really leading only up to this one principle, which was asked in the bar examinations many, many years ago. The principle known as laissez-faire. Many, many years ago, one of the questions asked in the bar exams was, do we still adhere to the doctrine of laissez-faire? Support your answer by adequate constitutional principles. 1%. Nobody could complain against the question because this was discussed in a case decided by the Supreme Court, in the case of Edu versus Elta, where the Supreme Court said, as early as the 1935 Constitution, we have already repudiated the laissez-faire doctrine, as shown by the many social justice provisions in the 1935 Constitution. Okay, what is laissez-faire? Laissez-faire is a French term that translates literally as let alone. It is supposed to be a cry of the private sector telling government, leave us alone. Huwag nyo kaming masyadong pakialaman. Do not impose many controls, many regulations on us. We can take care of ourselves. Leave us alone. In a free enterprise economy, laissez-faire is, of course, a guiding principle. The minimum of governmental intervention. Alright. But the Supreme Court said in Edu versus Ericta, even the 35 Constitution, we have already repudiated the laissez-faire doctrine. Now, class, I find this necessary to discuss only because in 1998, or was it 1999, in association of Philippine Coconut Desiccators versus Philippine Coconut Authority, the Supreme Court reiterated that statement and said we had long ago repudiated the doctrine or the principle of laissez-faire. In fact, if in Edu versus Ericta it was claimed that laissez-faire had already been repudiated because of the social justice provisions in the 1935 Constitution, with greater reason can we say that under the 87 Constitution, we have totally repudiated the laissez-faire doctrine. We have more social justice provisions in the 1987 than we had in the 1935. Okay. Finally, on government. Siguro pwede pa hanggang sovereignty pero hanggang sa ano na lang. And then tomorrow we start with state immunity from suit. And then police power of eminent domain. And then Article 2. We will finish all this tomorrow. We will try finish. But we will finish state immunity from suit. Even now I am convinced, 90% convinced that there will be a question on state immunity from suit. I am 80% convinced that there will be a question either on police power or eminent domain or both. But I don't know what the question is. I know the answer, but I don't know the question. So, okay, yun na lang. The final subject area of government that I want you to remember is the classification of governments. Particularly the classification of governments into de jure and de facto governments. Noong mga unang panahon, madalas itanong ito. Now, class, isa lang. A de jure government is defined in all of your books as that government that has legal title but does not have control over the machinery of government, as distinguished from a de facto government which has no title but has control of the machinery of government. You know, that definition is correct, of course, correct. But the definition of a de jure government as one that has title but has no control is correct only when a de jure government coexists with a de facto government. When there is no de facto government coexisting with the de jure government, then the de jure government has both title and control. For instance, if I were to ask you, how do you classify now the Gloria Macapagal Arroyo government? Is it de jure, de facto? Many people consider it the impacto. What is it? It's the jure government, of course. It has legal title and, well, it has control. Hopefully, anyway. It has control. Well, niyawa na dahil ako, sip-sip ako dyan. Kaya, so yeah. And then class, the three kinds, or the three forms of de facto government. Hindi naman masyadong mahirap din. Para na lang pampalakas loob na rin siguro. Memoryahin nyo na rin yun. That which takes possession or control of through force or through the will of the majority, the rightful legal government, and maintains itself against the will of the latter. Number two, that which is established by the inhabitants of a territory who rise in insurrection against the parent state. And third, that which is established by the invading forces of an enemy in the course of war, who occupy enemy territory in the course of war, which is also known as a de facto government of paramount force. Okay. But still on classification class, in light of mga naririnig ngayon na mga proposals for constitutional change, please prepare to distinguish between a presidential and a parliamentary form of government and a federal from a unitary form of government. Tomorrow we will discuss the fundamental principles and state policies. We will, although of course we will come to this again, we will have an opportunity to look at Lina versus Panyo and the more recent Judge Dadole versus Commission on Audit on ours being a unitary and not a federal government yet. The main distinction between a presidential and a parliamentary form of government is that in a presidential form of government, the powers of government, legislative, executive, and judicial, are allocated among three separate branches of government, each independent and co-equal of the other, and each not allowed to encroach upon the prerogatives of the other. In a parliamentary government, there is fusion of both executive and legislative powers in Parliament. Both executive and legislative powers are vested in Parliament. Although executive powers are exercised by a Prime Minister who is chosen by Parliament and who is accountable to Parliament and who may be changed at any time by Parliament by a simple vote of no confidence by Parliament. That is the basic distinction. Unitary and federal, of course, looks into the centrality, the centralized character of a unitary government as against a federal government which is supposed to be a group of independent states which have decided to bond together and give to a federal government certain of its powers. In the Philippines, it will be the other way around. We have from a unitary government, the central government now being willing to give to local government units independence or full autonomy to them, giving up a number of governmental powers, not just through decentralization, but actual relinquishment of governmental powers in favor of what will become independent and autonomous states, which will be the components of the federal government or the federal state. All right. Then sovereignty. Sovereignty is supposed to be the supreme and uncontrollable power by which the state is governed. Classifications or classes of sovereignty, legal and political, internal and external. Legal sovereignty referring to the power to issue final commands, the power to make laws. This is supposed to be vested in Congress. The political sovereignty refers to the sum total of all influences that make up for legal sovereignty. And this is supposed to be in the people. Sovereignty resides in the people and all government authority emanates from them. All right. Internal sovereignty is the power of the state that is exercised within the territory of the state. External sovereignty, otherwise known as independence, is freedom from any form of control, influence, intervention by other states. Then, of course, the characteristics of sovereignty: permanence, exclusiveness, comprehensiveness, absoluteness, indivisibility, inalienability, and imprescriptibility. And then, class, what happens when there is a change in sovereignty over the laws of a given territory? When there is a change in sovereignty, political laws are automatically abrogated unless the new sovereign reenacts them. People versus perfecto. In people versus perfecto, we have a case of a prisoner who had been ordered in prison because he committed an act against the Spanish crown. I don't know exactly what he did. He may have spat at the picture of the king, dinuraan, and so yun. In prison. After the Treaty of Paris of December 10, 1898, when sovereignty over the islands passed on to the Americans, he was ordered released. In fact, he was ordered released pursuant to a writ of habeas corpus. Municipal laws or civil laws remain in force even when there is a change of sovereignty, unless the new sovereign repeals them. Villas versus City of Manila, an obligation to pay a sum of money. The sum was not yet paid. There was a change in sovereignty. the debtor did not want to pay anymore because he said there has already been a change in sovereignty. Of course, the Supreme Court said that the obligation subsists because local laws, municipal laws, or civil laws remain in force even if there is a change in sovereignty. Finally, so we can start tomorrow on with the state immunity. Finally, the matter of belligerent occupation. There is a belligerent occupation when, in the course of war, enemy forces occupy the territory of the enemy. What do we have to remember in connection with this? Number one, that all political laws, including the Constitution, are suspended in application during the period of belligerent occupation, even if there is no change in sovereignty. There is no change in sovereignty, but political laws, including the Constitution, are suspended in application, except the law on treason. In Laurel versus Misa, the Supreme Court said that the law on treason, even if it is a political law, is not suspended during a period of belligerent occupation. Because, as the Supreme Court said, what the sovereign, the true sovereign, requires is not active resistance against the belligerent occupant, but merely passive allegiance to the true sovereign. Then, of course, the principle known as jus post dominium. When the belligerent occupant shall have been ousted from the occupied territory, then automatically the political laws which have been suspended during the period of belligerent occupation shall become effective again, automatic and re-effectivity, under the principle known as jus post dominium. So tomorrow we will start with state immunity from suit. It will probably take us 1 hour to 1 hour 15 minutes to finish state immunity from suit. Then we will probably spend 2 hours for police power and eminent domain. Extensive ang discussion natin dito sa eminent domain kasi kasama ang Article 13, kasama ang Republic Act 72-79, extensive ito. And then, of course, we go to Article 2. It is in connection with Article 2 that we will have a chance to look at the preamble of the Constitution. And so, 1:30 tayo bukas. Nakipagpalit si Colonel Cruz, 1:30 to 5:30 tayo sa political law, 6 o'clock to 9 siya ng registration. Our prayers na. In the name of the Father, and the Son, and the Holy Spirit. Amen. Glory be to the Father, and to the Son, and to the Holy Spirit. In the name of the Father, and the Son, and the Holy Spirit.
Kawawa naman si Colonel bukas. Hindi ko walang a-attend yan. Yung si Kapaod. Kasi tayo paglabas. Tired. I want to sleep already. Iyan. Uwi na ako para makatulog agad. Kain lang. Tara, go!
Malayo po yan na rin.
Uwi ka ngayon din sa... Bakit? Bakit?
Mga hihiling ka po ba?